Hi and Assalamualaikum. My name is Farah Nabila Binti Ishak
Hi, I am Ameera Hidayah Binti Rosli.
and we both are from DIA 3A. For subject Commercial Law, Sir Mazlan bin Abdulghani is our lecturer. Ameera and I would like to present for these two topics, which are Discharge of Contract and Remedies for Breach of Contract. These topics are from Unit 2, Law of Contract.
The definitions of discharge of contract is when parties to the contract are released from any obligations arises under the contract. In other words, parties to the contract are no longer obliged to do as agreed under the contract. There are 4 types of discharge of contract, which are discharge by performance, discharge by agreement, discharge by frustration, and lastly is discharge by breach. Firstly, let me talk about discharge by performance. Performance is the most common way to discharge a contract. A contract is said to be discharged when the parties to the contract has performed what they have agreed to do in the contract. For example, Siti offers to sell her handbag to Sheila for 150 ringgit. In this situation, a contract is said to be discharged by performance if Siti gives Sheila the handbag and Sheila gives Siti 150 ringgit. In order to discharge a contract, the performance of an obligation must be done strictly in accordance with the terms of the contract, unless otherwise agreed. This is evident from the provision of Section 40, Contracts Act 1950, which provides that a contract must be performed in its entirety unless otherwise agreed to the parties. The parties to a contract must be prepared to perform their respective obligations at the same time and place stipulated in the contract. The parties to a contract may also stipulate the time of performance as an essence of the contract. If that in the case, the Section 56 Contracts Act 1950 provides that any delay in the performance would entitle the innocent party either to terminate or continue with the contract. This was illustrated in Sim Chio Huat versus Wong Tat Fui, where it was held that the respondent was waived his rights to resign the contract when he ordered extra work to be done by appellant after original delivery date has passed. Next, Section 50 Contract Acts 1950 provides that where the place for performance had not been determined by a contract, then it would be the duty of the promisor to ask the promisee where he would want the contract to be performed if the performance is to be effected without the promisee's application. In executory contracts, a promise and its consideration is to be performed simultaneously at a future date. No promisor need perform his promise unless the promisee is ready and willing to perform his reciprocal promise. Section 52 Contract Acts 1950. Furthermore, Section 54 Contracts Act 1950 provides that where one party prevents the other from performing his promise under a contract, the contract is voidable at option of the party so prevented. Next, the tender of performance must fulfill the following conditions. Number 1, it was unconditional. Number 2, it was made at the proper time and place. The third one is it must be made under the circumstances that the other party may have the reasonable opportunity to ascertain the promiser is able and willing there and then to perform the whole of his obligations. And the last one is if the offer is to deliver something, the promise must have reasonable opportunity to see the thing offered to be delivered is the thing that promiser is bound to deliver. For the personal performance, whether or not the parties to a contract are required to personally perform their respective obligation depended on their intentions at the time the contract was made. Section 41 Contract Act 1950, where the performance of a contract is dependent on the personal skill of the promiser, it is implied that the must perform the contract personally. Where the personal performance is not implied, a promiser may employ a competent third party to perform his obligations, but he still remains personally liable. For joint agreement, it is where two or more persons have made a promise to a promisee under a contract. They are said to be jointly and severally liable under the contract. A release of one of the joint promisors from liability by the promisee will not free the other joint promisors. The released joint promisor is not released from responsibility to the other joint promisors. Section 45 Contract Acts 1950. Next, I'm going to talk about discharge by agreement. Contract may be discharged by agreement when parties to the contract agree under free consent to discharge obligations from the former contract. A contract can be discharged if the parties agrees or consent that the contract will be discharged. The agreement can be made during the contract or after the contract has been made. For example, Ahmad entered into a contract with Faisal. In the contract, both agreed that the contract will be discharged if the profit of the business is less than 500,000 ringgit in a year. If the profit is less, then the contract is said to be discharged by agreement. Section 63 of the Contract Act 1950 provides that the parties can agree either substitute an existing contract with a new one or rescind the original contract or alter the original contract. A novation is the substitute of the existing contract with a new one. The consideration of this new contract is the mutual discharge of the original one. A waiver or a release is where one party to a contract waives his rights by releasing the other party from having to perform his contractual obligations. The remission can be either wholly or partially as provided under Section 64 of the Contract Act 1950. The application of compensation or remission of a performance provided under Section 64 above can be seen under the following situations. 1. The payment of a lesser sum to satisfy the whole debt. Number 2 is payment of a lesser sum by a third party to satisfy a larger debt. The third one is payment in satisfaction of an unascertained sum. And the last one is an arrangement for the settlement of debts between a debtor and his creditors.
Next, we go to the last way to discharge the contract. It is discharged by the frustration. Discharge by frustration is like if the things that the parties agreed to do is impossible to perform, the contract can be terminated. This is because maybe the contract was made at the time or the contract has been obligation became very impossible to perform it. And in Section 57 Contract Act 1950 have said that contract the performance of which is impossible at the time it was made and the agreement to do is impossible to this and add this will make the contract constantly void. And next, a contract the performance of which had become impossible after some event that the promiser also cannot prevent. We can say it has been frustrated and indeed becomes void, but they are still have the qualification to be justified. It must not be because of self-induced or not because of parties themselves. It is something beyond their control and capability. According to the court, self-induced frustration is no frustration. Moreover, the performance must have been impossible and not merely more difficult or more expensive. Performance have radically different from that originally undertaken. Last but not least, the frustrating event has substantially prevented the performance of contract as a whole. There are circumstances in which a contract may be discharged by frustration. First, destruction of subject matter of contract. Second, two supervening events defeat the whole purpose or subject of the contract. You can refer to this case, Krell v. Henry. And next is true death or personal incapacity. Fourth, supervening illegality. And the last is declaration of war like burning petroleum mines. So, the effects when contract is discharged by frustration, a person who has received any advantage under it is bound to restore or compensate the person from whom the advantage was received.
The next topic that we are going to talk about is remedies. Remedy is a general term which means a right that can be claimed by a party to a contract that experienced losses because of the other party to the contract was in breach. The rights exist in many types: damages, specific performance, and injunction or quantum merit. Firstly, damages give to a person in a contract who does not receive the rights that he should from the contract. The aim of damages is to reward losses and damage because of the other party's breach. A person that claims damages must prove that the losses incurred because of the breach. The losses are commonly incurred and both parties expected the losses to incur if the contract is breached. In Tam Kyoto versus Associated Metal Smelters Ltd, court decided that a failure to send a smelter that could burn up to 2,600 degrees Fahrenheit is breach of contract. Defendant can expect the losses that might incur from the breach. The aims of rewarding damages are to give relief to the innocent party for the losses incurred, not to punish the other party who's in breach. Damages might be of specific or unspecific amounts. It depends to the terms agreed. Damages of specific amount are damages by which the amount has already been agreed upon if there is a breach. It has been agreed when the contract is being made. These are the classification of damages of unspecific amount. Firstly, substantial. A reward given is to put plaintiff in a place that he should if defendant performed the contractual obligation. Secondly, nominal. A small reward to plaintiff after he shows that there is a breach of contract, even though there is no losses incurred. And lastly, exemplary. A reward given is far higher than the losses incurred.
Let's look to the specific performance. This is actually an order from court to parties to a contract to perform as contracted and under Section Relief Act 1950. Court give order like if the contractual obligation is a trust, actual damage cannot be ascertained or breach cannot be adequately relieved by compensation of money. While for injunction, it is discretionary given by court under the Section 50, which is Past Free Relief Act. It could be mandatory or interlocutory. Interlocutory is used by a party to maintain status quo of a subject matter in a pending suit as the remedy. And mandatory, it is a court order to require something that has to be done. This injunction thing may be in form of restraining order or stopping something from being done. Lastly, for remedy is a quantum merit, which is a claim that can be made by plaintiff who has performed obligation under contract. Next, he will choose to rescind the contract after the defendant's breach. Thus, the court will order a value that is adequate, a reasonable sum of money to be paid for services rendered or work done when the amount due is not stipulated in a legally enforceable contract.
This is the end of our presentation. That's all from us. Thank you.